Well, this is a gay man expressing his opinion. No doubt that he takes these issues very seriously. And symbolism is important in our political world, but we need to be careful that statutes that become permanent parts of our criminal code are supported by evidence and a principle. I don't think that our focus here is to deal with symbolic legislation that's broad and could expand federal criminal jurisdiction beyond its historic role and where the facts do not support the need. In other words, a more narrowly tailored legislation consistent with constitutional rights could very well be something this Congress would want to pass. But to pass legislation that's extremely broad, they could give federal jurisdiction for the first time in history to every rape that occurs in America ought to be looked at with great care and ought not to be stuck on to a defense bill and move forward, in my opinion. The Constitution endows Congress with limited and enumerated powers. There's no general police power in the federal government. So at this point, I want to raise deals with the constitutionality of the fundamental act. Congress's power is limited to what it can regulate under the Commerce Clause. The proposed legislation is based upon the idea that a discrete crime in a local community may have an impact on interstate commerce. This is the same theory that was rejected in both U.S. v. Lopez and U.S. v. Morrison, where the Supreme Court essentially ruled that interstate violent conduct does not impact commerce normally. Nat Hentoff, a well-respected civil rights and civil libertarian attorney and writer, recently wrote about some constitutional concerns he has with the legislation. This is what he said, quote, "In the definitive constitutional analysis of James B. Jacobs and researcher Kimberly Potter, it is documented in Hate Crimes, Criminal Law, and Identity Politics that in Grimm versus Churchill, the arresting officer was permitted to testify that the defendant had a history of making racial remarks. Similarly, the people in People v. Lampkin, the prosecution presented as evidence racist statement the defendant had uttered 6 years before the crime for which he was on trial, as specifically relating to the offense. As for the 14th Amendment's essential requirement that no person be denied equal protection of the laws, there is carved above the entrance to the Supreme Court the words equal justice under law. This legislation, certain to be passed by the Senate now, it seems, will come to the Supreme Court. And I'm quoting Mr. Nat Hentoff, a well-known and respected civil libertarian, civil rights attorney. He said this, quote, when it comes before the Supreme Court, quote, "I hope the justices will look up at the carving as they go into the building. They should also remember that the Fifth Amendment makes clear, quote, nor shall any person be subject for the same offense to be twice put in jeopardy. But the House Hate Crimes Bill," he goes on, "allows defendants found innocent of that offense in a state court to be tried again in federal court because of insufficiently diligent prosecutors, or as Attorney General Holder says, when state prosecutors claim lack of evidence. It must be tried again in federal court." Imagine Holder as the state prosecutor in the long early stages of the Duke University lacrosse rape case. What also appalls me as a new federal bill races toward a presidential signature is that for many years and now, the American Civil Liberties Union approves hate crime prosecutions. I have long depended on the ACLU staff of constitutional warriors to act persistently against government abuses of our founding documents. And these attorneys and analysts have been especially valuable in exposing the results of executive branch lunges against the separation of powers in the Bush-Cheney years, and still under Obama. Then he asked this: is there no non-politically correct ACL lawyer or other staff worker or anyone in the ACLU affiliates or any dues-paying member outraged enough to demand of the ACLU's ruling circle to at last disavow this corruption of the Constitution? Close quote. That's Mr. Hentoff's view of it.